days. So, Ms. Gillette, we'd really like to know what
No
we've been
comment.
charged
I've
with.
told you no comment. Do not harass or stop.
Ma'am, I'm asking you questions. I mean, Deputy Love says we've been charged with 22-15 or 21-5922.
Why are you lying about us in court? We don't have that medical stuff.
You
know it.
disclosed the medical records,
You
not
disclosed
us.
it yourself, Jill.
Is
that allowed,
that's a pretty
Jill?
serious
You
You
offense.
guys
just
should
lie.
not be filming
Why
in a
not?
judicial
Oh, right. I
area.
thought it was a
There are
court.
rules
Isn't-
not to
yeah,
film in
the court-
judicial
Yeah,
areas.
this is a
We're not in
constitutional right
We're
that
like
you
right
guys down
outside
here
your
are gonna
bathroom.
have to understand.
I've told you I have no comment. If you don't stop following
We can
me, I
continue
will
to
charge
ask
you with
questions.
stalking.
You're gonna
We
charge
can
us with
continue to ask
stalking.
questions,
You're gonna
Jill.
charge us with
You lied
stalking.
about us in court. We'd like to know why.
Do
No,
not
no,
comment
no
on
charges
all
listed, huh? So you're actually investigating us? Are you ever gonna tell us if we're charged, or is this just a criminal trial that happens without any kind of oversight at all? You just rule it yourself? Do you often lie in court? Judging from what we're hearing, it does seem that that's the case. You gonna share it with us? If I give you an upload link, will you share that with us?
Do you guys have any other questions?
I do. I'd like to know about that duck.
Thank you.
Did you kidnap a duck, Jill? I hear you kidnapped a duck and threw a fit inside your house when the police came to get it back for the owner. Is that true?
Jill, is this stalking? Is this stalking? Did you know that the stalking statute says that it doesn't apply when you're conducting official business, especially in the public? If you were trying to charge us with some bullshit charges,
Yeah.
asking you about it, you said, "What would charge you with stalking now?"
Flaunting your laws, huh? Don't pull the door on me, you dumb bitch. Don't pull the door on me. You called me a criminal, you dumb bitch. I'll call you whatever I want.
The south one, please.
You're kind of competing with that diesel generator out there.
Welcome to Elk County.
Yeah, there you go.
All right, this is case number 24 DM 17, Jill Gillette versus Philip Irving. Irving. This is, have counsel state their appearances, please.
May it please the court, the plaintiff appears in person. Permission to stay seated to remain on the record clearly.
Linsdale Baker appearing in person for the respondent, Mr. Irving, who also appears.
We're continuing a case from, I believe the 18th, 2 days ago. The plaintiff had presented part of her case in chief, and that's where we were interrupted. Before we get started with testimony, Mr. Baker, you had indicated the other day you had a commitment to a federal court. Scheduling wise, what do we need?
Yes, Your Honor, I've got an 11 o'clock telephone, and I've told your clerk if you can just cut it at 5, give me 5 minutes prior to. I don't think it'll take more than 15 or 20 minutes.
Okay, if you need additional time than that, let me know. I sometimes get caught up with what I'm doing, so please watch the clock if it's getting to that point. If there's a natural breaking point, we'll try to accommodate that, but we'll take that break. In regards to my calendar, it looks like I should have only one thing, first appearance at 1:30, so we should be able to get going by 2 o'clock, depending, and we may go some through the traditional noon hour we'll give everybody enough.
Judge, I do have a meeting at noon. I'm part of the Access to Justice for Rural Area Representatives that helps the underprivileged get access to courts.
What time is
attorneys.
your meeting schedule?
It's from 12 to 12:30, 12:45, somewhere around there.
Okay, thank you. All right. Any other preliminary matters, counsel? All right, there was a sequestration order earlier that will still remain in effect. So if there's any witnesses that were present before for either side that haven't been released from their subpoena, they need to step out, please. And counsel, I'd ask that you take a peek and make sure to everybody that you anticipate calling. Everybody good? Okay. Ms. Gillette, you may continue. You're calling yourself as a witness? All right, if you'd raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. You're under oath.
Judge, if I may, as a preliminary matter, the witness is bringing up documents to the witness stand. I don't have copies. I don't think she's going to be reading from them.
Judge, it's a copy of the petition.
Hold on. How I do this, we do this with officers all the time. They take up, if witnesses take up documents, if they're referring to documents, then yes, the council have an opportunity to look at those documents. I don't let witnesses just read from the documents. If it's a document that needs to be admitted as an exhibit, then and it's properly offered. If it's admitted, it certainly doesn't need to be read into the record because I can read it myself.
Well, just as a clarify, she's got notes. It's not a document. She's got little pasty notes over there that she's going to refer to. So it wouldn't even be a document. It's something she's going to use as an outline, and
All right.
I think that's proper.
Okay, Ms. Gillette, what are the sticky notes?
The sticky notes are my notes as to referring to the exhibits, which he does have a copy of the emails that were attached to the petition, a copy of the petition so I can follow through and remind myself of dates if I need them. And these are my sticky notes as to what I wanted to specifically refer to in these notes, in the exhibits. And these are my personal notes on their exhibits for when we get to their portion. So they're just here so I don't lose them.
Still personal notes. I mean, it's
Mr. Baker, we have a situation where the person's representing themselves. As an attorney asking questions, if you're asking questions, you may be the rare exception, but most attorneys have notes and so forth. So I see that as work product.
her own notes as a pro se.
Well, yes. If you're talking about in regards to what items that she wants to question herself about, and things to that effect, yes.
Pro se has work product, Judge? I mean, all I'm saying is I can't see the notes that she's taking up and reading from because you're ruling it's work product from a pro se.
I'm saying that she has a right to have notes in regards to what areas she needs to cover.
Can I see them?
No, that's going to be work product. All right. So the witness is under oath. You may make your testimony.
Your Honor, I brought this case to ask, it's hard to not ask yourself questions, so I'm going to go through a few of the things that occurred that are not protected. And so, on July 29th of 24, Mr. Aravi followed me from my office down to the elevator. We went down the elevator and then into the commission room. He continued to try to question me during that time, was close to my person, which makes me have a concern for my own personal safety. It was clear that there was other concern for me because I ended up having a deputy escort, which was Deputy Joe Love. They are constantly on live stream. I do not access their live streams, Facebook pages, anything of the such. I've been sent numerous links, still shots. I don't care to look at those because I know, pursuant to the law through the Phelps case, that what's on their pages is their pages. But when it crosses the line to come...
Right. This is not an opening or closing argument. This is testimony. So
right.
Testimony in regards to factual basis or facts is what
Correct.
This portion is for.
And the fact is, I don't look at any of the social media or news, what they consider themselves as, they consider themselves a news outlet. They're not KPA, but I don't consider them news. But I don't look at their social media. None of this is based on any of their social media or their presentation, as they call it publicly. It's specifically interactions between them and I. So on July 29th, he followed me down to the commission meeting. I had an executive session about security for a trial in the courthouse when they're here and present, as well as other things that go on that's related to security of the court and the courthouse. After the meeting, he followed me to my car. He questioned me the entire way to my car, yelled at me. Deputy Love accompanied me. I noted that when we went through their exhibits, that video is not included. I believe it's not included because it is conduct.
It's argument. It's not fact.
What? Okay.
It's conduct that is not speech. Walking out to my car, following me, putting my car on live stream, having photograph video of my car designates what my tag is, what my car is.
Okay, hold on. This is argument, and that's fine in the appropriate context. The facts that you're talking about was someone followed you to your car. That's a fact. That's fine on testimony. Your interpretation of case law or those things aren't, no, that's going to be appropriate for argument. So I'd ask that you limit your testimony to facts as though this was being, attorney questioning you.
It's a fact that he now has my tag number. It's a fact that he now has the make and model of my car. It's a fact that he now knows that I have a foster kid whose name would be on the back of my car and what my foster kid's name is. Those are all personal information. It is a fact that he stood at the back corner of my car, and after I got in my car, I had to wait for him to stop yelling and move on before I could back out and leave the courthouse, which caused delay in my departure from the courthouse. It gave me concern that he walked all the way out to where my car was and didn't stop at the courthouse doors or back where it would be clear that he was not invading personal space. He walked clear up to the back driver's side corner of my car, of my SUV, and I was in my white SUV that day. That is conduct. It's physical. It's not speech.
Object is argumentative.
It is. Please refrain to the testimony of.
On September 9th of '24, there was a commission meeting, and we saw that video. Partly, the beginning part we did not see, but I came down to speak to the commission. Again, we had another executive session about court security, courthouse security with the sheriff, myself, the commission, and County Councilor Dean. Prior to going into that session, he kept talking to the commissioners. We ended up having our executive session. I came out to deal with a surveillance camera. After I left the meeting, I went up to go upstairs. He continued to yell questions at me about the duck. The duck is a issue that happened in Fredonia, Kansas. I lived outside the city limits of Fredonia, Kansas at the time. And I, as you know, lived out in the county. I am the owner of multiple ducks. I now own chickens. I own 4 dogs. And I basically have a small hobby farm of waterfowl and poultry. I have given lots of advice to many people, and I run a rescue. I have multiple rescue ducks over the years. I've been doing, we had ducks years and years ago, and then we stopped having ducks for a while, and then I got ducks again starting in 2020 during COVID. I was off work, and it gave me something to do. And as someone who cares for waterfowl, I carry medications all kinds of things. I have a vet on call that works with me with waterfowl. I have a pet duck that lives with me. And so I was called about a duck that a little boy had with him and brought to a friend's daughter-in-law's house. They didn't know what to do with it, so they gave it to me to care for until whether it was located as a wild duck or whether a family was recovered. I know the breed of duck because I can identify them, that it was a mallard, and mallards can be wild or domesticated. So an investigation was conducted later when the individuals who owned the duck got home significantly after work. And the family for that duck was located. A police officer came to the door, and as you know, my ex-husband had dementia, and he had been screaming and yelling all day and all evening. And particularly extremely bad that night. And he had interaction with the officer downstairs, came up screaming and yelling at me. And then later on, I went down and got the little duckling and took it to the officer to return to the family. And that is what happened with the duck. How the duck came to be in the little boy's possession, I don't know. But because I am well known for being able to care for animals, I had it. There was a report made by the local officer. I don't know what was in his report, but the little boy who had the duck had taken it over to an individual's home, and like I said, that's how I ended up with it, because they knew I could care for it and have it feel set up at all given times. So the duckling was cared for until the family was found. Mr. Araby clearly has been poking around with the Fredonia PD to try to find any kind of incriminating information.
A cause for speculation.
That may be argument. Again, please refrain from argument, and facts to support that argument is basically what this is, to give out facts. So please refrain.
So all the way up the staircase in the lobby, he's yelling at me about a kidnapped duck. And I don't believe you can kidnap a duck because it's an animal, but he yelled at me all the way up the staircase. At the top of the stairs, we watched the video 2 days ago, and you can see that I started to close the door behind me. I was in the motion of shutting the door when he yanked it out of my hand. I did not turn around or say anything to him when he did so. I walked into my office, and I had my key card with me in my other hand, and I wear a wristband, so I had my key card with me. And I buzzed myself into my office and then went in to calm down from them yelling at me all the way up the stairs and ripping the door out of my hand.
Which door are you referring to?
The door at the top of the stairs. We watched the video 2 days ago where he yanks that door open.
Double doors that separate the landing from the hallway?
Yes.
So we're not talking about the door to your personal office?
No. So when that door was yanked out of my hand, it did cause me pain and harm. For 3 days, my hand was swollen. They don't know, but I will tell you, I've had carpal tunnel surgery in that hand. I have permanent nerve damage in that hand. I have de Quervain syndrome in that hand. And I have tendinitis on the far side for overcompensation from the de Quervain syndrome. I am under the care of doctors. I do take medication for the permanent nerve damage, and my hand was swollen for 3 days. I live with excruciating nerve pain down my right arm daily for my entire life since I was 20 years old in a terrible car accident. After that occurred, I debated on whether or not to file a protection case, since they have now physically followed me twice, once causing damage.
All right, you've used that term "they." Now, Mr. Hervé is the one you're referring to as he?
Yes, Mr. Hervé followed me on the day of my car and on September 9th, which was July 29th, and September 9th. He followed me both times. So I debated whether or not to do something then. I did make a report for battery with Deputy Love. I have spoken with 2 different prosecutors, and one is very interested in
Objective,
cases.
speculation, and hearsay.
Sustained.
So those cases have to be referred out now, everything that it deals with them since I'm a victim. There's no evidence in the video of me holding the door shut. He literally ripped it out of my hand as I was in the motion.
It's no evidence. It's argument.
Sustained. Please refrain, from your perception of how things in regards to interpreting videos and things that are admitted as evidence, that's argument. So please continue.
In the video, you saw the door was flung so hard it smacked the wall, and it made a loud bang.
Let the record reflect she's just reading from...
No, I'm not. That's not exactly in my notes. This is just to refresh me.
Overruled. Please continue.
Now, after I had those instances, I have continued to receive emails from him. I don't respond to them. He asserts that all of the emails are communications with an elected official. The protection for communications is it must be revolving around...
This is argument. Please. I don't want to have to keep going this. Tell the test, give the factual things that you want the court to know for evidence.
Petitioner's Exhibit 1 is attached to the petition. It is an email dated September 26th. It's from Mr. Hervé to myself. And it says "The Catalyst is You" is the title. And it is mostly just attacks to me personally.
All right. Are you moving for the admission of plaintiff's A?
I have it marked as 1. They have theirs as letters.
Okay. What was in your petition as plaintiff's A?
The actual exhibit's marked as 1.
Okay. And is that present?
It is.
All right. So are you moving for admission of plaintiff's 1?
I am.
No objection.
Plaintiff's 1 is admitted.
I draw the court's attention to the last lines where he threatens to follow my entire career to the end. Even if I went into private practice, that makes me believe that he would follow me even into private practice. I'm moving to admit Petitioner's Exhibit 2. It's the email from Mr. Hervé to me dated August 18th.
All right. It's number 2. What was on the petition is B.
Yes.
Any objection?
No objection.
Plaintiff's 2 is admitted.
And I would draw the court's attention to the contents of it. On 2, he talks a lot about stuff not related to the case and issues that are definitely outside of the Walker case they are following. And Petitioner's Exhibit 3, which would have been C on the petition, is the email dated September 9th. Now, this email is a follow-up to a request for Cora.
Is it offered as evidence?
It is going to be offered as evidence.
Any objection to plaintiff 3?
No objection.
Plaintiff 3 is admitted.
And I would draw the court's attention to the last line that says, "In jail, I really do have a lot of questions about your obsession with ducks." That has nothing to do with the case.
Argumentative.
Overruled. Please, next.
Petitioner's Exhibit 4, which should be D on the petition, is the email from July 9th 2024. It is the Cora request that he made to everyone at the county.
Okay, are you requesting it to be admitted as an exhibit?
I am, Your Honor, just so that you have an understanding that it was a Cora request.
No objection.
Plaintiff's 4 is admitted.
Petitioner's Exhibit 5 is E on the petition. It is dated July 3rd, 2024. And it's another email from Mr. Aravi.
Okay, is that marked as stage 5, excuse me, plaintiff's 5?
Yes, petitioner's 5.
No objection.
Offered?
It is offered.
No objection.
5 is admitted.
And petitioner's Exhibit 6 would be F. And it is an email dated Sunday, July 21st, 2024.
Is it offered?
It is being offered.
No objection.
Plaintiff 6 is admitted.
And plaintiff's Exhibit 7 is an email dated Wednesday, October 30th, 2024.
Okay, hold on. Is 6 a 2-page document?
6 is a 2-page document.
Right. And plaintiff 7 is,
G on the original petition, and it's the email Wednesday, October 30th, 2024.
plaintiff 7 being offered.
Yes.
No objection.
Plaintiff 7 is admitted.
Now, since the petition was filed on November 6th, I was present for the beginning of the jury trial for Mr. Walker. I had been in the judge's chambers with Judge Ricky, Chris Pate, and many other individuals. And my sister died that morning. She did not wake up. And our family carries an underlying health problem, as you're aware, with my heart. And therefore, with my heart, we carry a genome that can cause sudden nocturnal death syndrome in adults, and we could die at any time in our sleep. My sister died, and they suspect it was either her heart or a blood clot stroke.
It's got cause for speculation.
It's on our death certificate.
Okay. All right. Well, all right. The death of your sister is a sad and situation. I don't know that we need to have the whole history there. The fact that she passed away and this was the morning of trial. Please continue in regard to relevant issues concerning November 6th.
So when we stepped outside of Judge Ricky's chambers, and I was in the hallway, Mr. Aravi left from the clerk's office window. We saw that video of where he left from there. There's not a camera at the top of the stairwell outside the judge's chambers. He left from there, came up behind me, was standing about 2.5 to 3 feet behind me, dropped his cell phone. He caused a big bang on the floor, which startled me. I saw somebody come towards me, and so I looked to see who it was. When I saw it was him, I looked at Deputy Hanson, who was there with me for security. Deputy Andrews was near the area and moved towards us to also watch him. We were there briefly for probably less than a minute that he approached me. Then it does give me concern that he approached me knowing this case was filed, to be near me, to possibly either record me or listen to what I had to say. So I motioned to Deputy Hanson that we should leave to my office, and we went to my office so that I was not near Mr. Araby, and I moved myself out of the vicinity of him just so that he could not be near me to cause any more physical contact with me. Physical contact is different than
Argumentative.
others, so the physical contact gives me
Again?
fear.
Okay. That portion's permitted. Go ahead.
I do have fear of Mr. Araby. I am trained to stay calm, even if I am shot at, and to think clearly to get to where I need to be. I do have former training as an EMT that also helps me stay calm in these kind of conditions. I also have training as a first responder. And I've been put in other positions to be in dangerous situations, even being at crime scenes to try to stay calm, cool, and collected and be able to think outside the box. So I do stay calm on the outside, although I do have fear he is going to hurt me. Mr. Spees has walked with him to follow me within the courthouse, but when I was followed to my car, Mr. Spees stayed at the door of the courthouse. He did not follow me directly to my car like Mr. Araby did. He didn't stand behind my car. Mr. Spees backed off on the day of the door being yanked out of my hand. You can see it in the video that was shown 2 days ago. Mr. Spees did not approach me during the trial. He stayed at the clerk's window and stayed away from me.
Judge, it's irrelevant
Mr.
about
Araby-
Dr.
Well,
Spees.
okay, sustained. What somebody else didn't do, I don't find to be relevant.
Well, the defendant brought up in their opening arguments that no one else is being sought protection orders. Mr. Araby is the one who gets close to me every time, invading my personal space. And Mr. Araby is the one who caused physical contact with me. It is difficult to do the job that I am in anyway, but having physical contact gives me fear. I've received other verbal and written threats before, but this is an individual who has physically followed me more than once, physically gotten close to me, and physically caused harm to me.
When you say he's gotten close, what do you mean by close?
Within 3 feet of my person.
You mentioned personal space. What are you referring to as personal space?
Personal space to me is about a 2.5, 3 foot radius of a person. It's different, like if you're in an elevator situation. They have not gotten on the elevator with me, but they have physically been close to me. Like when I'm trying to get on the elevator and waiting, that's a small hallway up here at the top of the stairs. My only means of exit would be through past them if the elevator doors don't open. And they block that way, especially Mr. Araby is the one usually closest to me. He was the one closest to me on that occasion. He is the one closest to me when I'm going up the stairs, and then he approached me during the morning of the trial. And he walked right past me and then stood about 2.5 to 3 feet behind me, where I couldn't see him.
Are you finished with your testimony?
He continues to email me consistently, weekly. If it's relating to the case, I don't generally take notice of it. If there is anything that's a threat in it, I take notice of it. If there's anything in it that's personal, again, there's things that he wouldn't know unless he went to go talk to different individuals.
Argumentative.
So
Sustained.
I just pay attention to if there's something in there that's dangerous to me. And I have had threats from their followers, but that's not him making the conduct. It's caused by his statements and behavior, but it's not him doing it. So that's why I did not put it in the petition.
Anything else?
I can't think of anything else, Judge.
Right. If you have anything that are part of notes as to, that you would have in regards to remind you of what you needed to testify to, those need to be put away. Any documents or notes of facts, those you can be kept there, and counsel can review those as asked. But she's finished with testimony. Okay, you've turned over things that still had sticky notes on there. So what are we talking about here?
The only thing I have is a case law case for later argument and my notes I made in the margin of the petition. So I don't have anything other than, these are the notes regarding their evidence. The rest of this is just bullet points of what I testified to.
Not to refer to those or to refresh your recollection with those during cross-examination then. If you need to look at if you're asked about the petition, then a copy of the petition can be provided. Ready to cross-examine?
Thank you, Judge. Ms. Gillette, these weekly emails, are they the ones that you've admitted in evidence?
These are the emails that I've received from Mr. Airby.
When you say weekly, those are the emails.
I don't know that I said weekly, but I get frequent.
Yeah, you said
from him.
he emailed you weekly. You don't remember testifying to that today?
I don't remember what I specifically said.
You just said it 2 minutes ago, and you don't remember
I'm
saying
going to object to arguing with me. I don't remember the exact wordage.
Okay. And in any event, if you testified that he emailed you weekly, the only emails you're referring to are the ones that you admitted into evidence today, correct?
These are the emails, yes.
You talked about your medical history. You talked about medication. What other prescriptions are you prescribed?
I take metoprolol. I don't know that it's relevant, but if you want to, I take
Well, is it an
metoprolol.
objection or not?
Object to relevance.
Okay, the nature of the medications that she takes, if counsel wishes to ask if those somehow interfere with thoughts and so forth,
Well-
as to item by item of a person's personal prescriptions, I'm not sure it would be relevant.
Well, she has talked about trauma and emotional distress. She's taking medication for anxiety. I think that's relevant to her perception.
That type of medication, yes, if there's things that typically would have a warning of some sort in regards to not operating heavy equipment, that sort of thing. But I don't want things going to any and all.
Well, and I don't know what she's taken, but have you been prescribed medication for anxiety?
I have.
And what would that medication be?
I have two.
Go ahead.
I have hydroxyzine and I have Ativan. They are both PRN. I rarely take them.
I get that. Now, the next question is, how long have you been prescribed those anxiety medications?
I was prescribed them in 2022
Okay.
when my spouse got dementia.
Okay. Now, and are you currently taking anxiety medication?
I do, occasionally.
Today, did you take any?
Nope.
Okay. How often do you take your anxiety medication?
It's so rare. Once every 2 months,
Okay.
maybe once a month.
Do you go to therapy for anxiety problems?
I have a psychologist that I talk to. She's a PhD in psychology.
And you go to her because you have anxiety issues?
I go to her because I have severe issues that I have been through in my life.
Anxiety being one of them.
Not the anxiety so much as processing the death of my son.
Okay. All right. And so and how often do you go into therapy for that?
Once a month.
Okay. You, on July 29th, you remember that video that was shown there by the elevator?
I do.
And you told Mr. Irving that he could not be filming you at that place, didn't you?
He's in a judicial area and there are signs all
You
over up
told
here.
him he couldn't film, correct?
Correct. He should not film in a
And-
judicial area.
And that's a misrepresentation, isn't it? You said you can't film him in a judicial area, and that's incorrect, isn't it?
No,
That's not a judicial area in that hallway by that elevator, is
it
it?
is.
Counsel, that's argumentative. As to facts as to what was said and so forth, that's relevant.
Okay. And you consider this entire building a judicial area that cannot be photographed?
The second floor.
All right. Not just this courtroom, but the entire hallways and all that, correct?
I do.
And do you know if that opinion is shared by the judge or anybody else in this building other than you?
It is.
Is there a rule in Elk County that filming is barred other than in the courtroom, as far as you know?
Currently, Judge Ricky has had signs posted for the courtroom.
I'm asking about other than the courtroom. Is there any rule?
I'm not aware that Judge Ricky has imposed it in the hallways.
Whoever might have one, is there any rule other than in this courtroom that bars photography or videotaping?
I'm not aware Judge Ricky has changed that rule.
Anyone else?
No.
Okay. So there's no rule that bars videotaping that you know of outside this courtroom, correct?
Incorrect.
And where's that rule that bars?
Statutes say in judicial areas.
Okay. You wanted this proceeding to be closed, didn't you?
I did.
Because you didn't want bad publicity.
No.
And you are a law enforcement officer of Elk County?
I carry a badge and I am the Chief Law Enforcement Officer of Elk and Greenwood County.
And so that's a yes?
It is a yes.
And if I can approach, I'm going to hand you the
But,
exhibit.
hold on, what are you approaching with?
Exhibit C, it's her petition.
You mean?
So let me hand you Exhibit C.
Okay, counsel, we don't have a court reporter, so before you start speaking again, if you can be by a microphone, please. Thank you.
And, Judge, look, I'll give you what I've marked as Exhibit C.
This is defendants or plaintiffs?
It would be her, but I've marked her petition in this matter as Exhibit C.
Defense Exhibit C.
Yes. So this is Defense Exhibit C. If you look at page 2, you do say I'm a law enforcement officer when I'm working or on official duty,
It is correct.
and you're talking about your official capacity as prosecutor.
It is.
Why did you put that in your motion?
Because I am. And I know that it makes it difficult for me, but I am.
In terms of what? What difference does it make in terms of your allegations of stalking that you're a chief law enforcement officer of Elk County?
Because it's pertinent for the judge to consider under all of the case law as to whether or not it interferes with my personal life or my official life.
Okay. And you would agree that a criminal investigation or a criminal prosecution is a matter of public concern?
The criminal prosecution is of public concern.
Okay. Or criminal investigation? How about that one?
It could be.
Okay. You say the First Amendment, hate screaming at individuals in person is not protected?
Is that in the petition somewhere?
Yes.
What line?
Well, just let me ask you the question. Is hate screaming at individuals in person protected speech, in your opinion?
It depends on the situation.
When can you hate scream and it be protected?
Okay, counsel, is hate scream a term of art?
In her petition, she refers to it. I'll see if I can find it. Let me move on. It's in there. I'll find it. But if you use the phrase hate screaming at individuals in person, and then you cite Sampson, a case called Sampson, you see that?
Mm-hmm. What page is it on?
Page 2.
Page 2.
Bottom of the page.
I don't see where I used the word hate.
I said you cited to Sampson. See that?
I cited Sampson.
Okay, that's all I need. I'm approaching with Exhibit G. I'm handing it to you.
This is defendant's G?
Yes. And looking at this case that you cited in your petition, it refers to, on the next to the last page, where the court cites language being used.
I'm going to object as this is legal opinion and appropriate for argument, but not questioning.
You cited it in your petition. I'm asking you if you're aware of what Sampson says.
That's permitted.
The part that I cited had nothing to do with that. That part's irrelevant.
I don't really care. I'm talking about Sampson and what it says. You see what it says there? That calling someone, quote, stupid son of a bitch, and other words, clown, big fat ape, smart aleck, big fat oaf, and stupid son of a bitch is protected speech. Right?
It can be, depending upon the situation.
They said it's protected. You don't agree with this?
Not when it's coupled with battery.
Okay. Now, and the worst word that you remember Mr. Irby saying to you was what?
Over the course of our interactions, he's used the word cunt, bitch, all kinds of different words.
Okay, you've cited 2. Anything else you can remember as bad words?
I think it's his followers that say Nazi baby killers, not him.
Okay, and you're not holding him responsible?
No.
Okay.
That's why it's not in there.
But you bring it up in your complaint as though he's responsible, don't you?
They are his followers, and he gives them our information.
But he's not responsible. He can't be held responsible for what they might say, correct?
That's correct. One of his followers has actually threatened to kill me and admitted to it on
Please
Facebook.
just answer the question.
As the chief law enforcement officer of Elk County, you possess one or more firearms?
I do.
How many?
Ooh.
Counsel, how is that relevant?
She is able to protect herself, Judge. She is a law enforcement officer. She can probably bring a firearm into this courtroom.
What does the number of firearms an individual owns, how is it relevant today?
Okay, let me just get to the other question. But the fact that she has a firearm, all right. And are you permitted to bring a firearm into the courtroom?
I am.
And into this building?
Yes, I am.
Do you have one in here today?
I do.
Where is it?
On my chest.
All right. What kind of pistol do you have on you today?
I have a 9mm Glock G43. Not the X, the regular G43.
Loaded?
Absolutely.
One in the chamber?
Absolutely.
Did you tell the deputies here you got concealed weapon on you?
My sheriff in both counties encouraged me to carry because sometimes there's not a deputy in the courtroom and it's my job to protect the judge. And I go to qualifications with my officers every year. And I do the same test and I practice every 2 months. Yes.
Got it. Got it. So all this about you being scared and you packing a 9mm with you, and you probably had that on you when all the other times, too?
Well, no, not one. Not one of them.
Well, on the events that you talk about, July 29th, were you packing that day?
That is the one day I didn't have it.
Didn't have it.
Mm-hmm.
But the September 9th, this other one?
Yes, I did.
In the elevator, you had that firearm on?
Absolutely.
Okay. You said now that on page 2 of your motion, September 9th, 2024 meeting, said you saw Dr. Spee's video of the meeting, and you characterized Mr. Irvy's speech at the meeting as yelling. You've said that over and over here today, right?
Yes, I feel he yelled. It's a personal objective.
Excuse me?
It's personally objective.
Personally objective. What are you trying to say? What is that?
You might think something's not yelling, and I think it's yelling.
Right, right. So
it's objective.
Yes, and you think that whatever volume that video showed, whatever that volume was, you say it's yelling.
Yes.
Right. So it'd be fair to say every time you say yelling, we can go to that video and listen to the audio, and in Jill Gillette's mind, that's yelling.
It was.
Okay.
He elevated to the point of telling him to get out of the way.
You say he lunged at the door. Now, you allege this from what? You didn't see him do that.
As I turned around to shut the door, I saw him jump out for it to pull it, and you can see it on that video.
You say he lunged.
Mm-hmm.
Okay. And, there's a security camera on the other side of that door, isn't there?
There is.
You didn't put that into evidence, did you?
Nope.
Because it would have shown that you tried to hold that door closed.
Nope.
And those security cameras don't have audio, do they?
No, they don't.
How did you get access to those security cameras?
The same way you can subpoena Ducis Tecum.
And you subpoenaed those personally?
I subpoenaed the sheriff, subpoenaed Ducis Tecum through the legal process of the court, asking him to bring the specific videos. You can access that subpoena on Odyssey.
In the subpoena that you say that you submitted, it has a Ducis Tecum to it?
Yes.
Bring all the videos. And you're saying you hadn't reviewed those until the day that he brought them here?
Correct.
Okay. And how many you didn't make an open records request for them, did you?
When you subpoena an officer...
All I need is a yes or no.
Oh, no, don't have to.
Okay. And how many videos, security videos, did he give you?
The one I specifically subpoenaed the time frame for.
How many? I saw a bunch on that laptop. How many did he give you access to?
Just the 1 hour of footage Now, if you want me to explain how the system works, I can
No,
explain
okay.
those.
You're telling me he only gave you an hour's worth of various security footage on different cameras?
There's 4 cameras
Okay,
for the
at
hour.
a certain time, okay. And you say in your motion that Deputy Love heard this loud bang and he came upstairs to see what was going on. Remember?
Correct.
But the video doesn't show that, does it? He never came up there at all in terms of that bang, correct?
I went off of what he told me and when we talked for my part of the investigation.
All right. So you know that's not true, what you
I never
alleged.
looked at the video.
You know that's not true, what you alleged. He didn't come up there, did he?
I found out the same you did in his testimony.
Let's admit it's not true. Can you just do that?
I went off of what the deputy told me at the time that
Right.
we had my
Fine,
investigation.
fine, don't admit it. But it's not true, right?
He said he went to the bottom of the stairs.
No, you said he came up the stairs. You know that's not true. Correct? You said...
Asked and answered.
Yeah, you haven't, okay. You said that Mr. Irving was screaming profanities and name at me the entire time behind me,
Yes.
right? And you think that's substantiated in the video?
I think he yelled at me all the way up the stairs.
With profanities.
Did
didn't do
you
that, did
not hear your client scream bitch
Did
at
you
me?
not argue with me? You're saying he came up the stairs yelling profanities?
Yes, he said bitch multiple times.
Oh, as he came up the stairs.
And
right.
asked me about the dog multiple times.
Now, Judge, I need to take a break. I've got that telephone.
Yes, we're in recess until Mr.
Baker.
Baker, excuse me, trying to read and...
No, I got
At the
it.
same time. We're in recess so you can take care of your hearing.
Thank you, Judge.
We'll reconvene when you're back. We're back on the record. Mr. Fletcher's on the stand. Defendant and counsel present as well. It appears that the sequestered witnesses are still out of the courtroom, so we'll proceed.
Yes. You referred to someone as your husband, and then in one of these motions you talk about a boyfriend. Is that the same person?
No, I'm divorced recently.
Okay, so the man you're talking about as your husband, you're divorced from now.
Yes.
Right. And then this boyfriend that you talked about, that's somebody subsequent to that.
Oh, yeah.
I'm going to hand you, if I can approach, Exhibit D, which is what I call the Walker motion. And you recognize Exhibit D?
I do.
And in that motion, you characterize both Mr. Irving and Dr. Spies as media.
Yeah, they believe they're media.
You characterize them as media, correct?
Because that's how they define themselves.
Okay. In fact, you claimed they didn't conduct themselves as local media, correct?
No.
You don't think you said that the local media did things differently than this media?
Maybe
That
I
motion?
misunderstood your question. They're not local media. They're not from here.
No, I didn't say they were local media. You said that this media didn't do their journalism the way that this local media conducted themselves in that motion, correct?
Correct.
Okay, now, And you asked for a restraint of media, which was in part Mr. Irving and Dr. Spees, if you look at page 3.
Correct.
Against the media and against the news agency in page 5, correct?
It's a partial restriction request.
It's still against the media and news agencies, which you characterize as Mr. Irving and Dr. Spees, correct?
Yes, and I'm going to object to these as being irrelevant. They have to do with the Walker case. They don't have to deal with the physical.
Well, I'll explain that. It's relevant.
Okay, there's an objection. If you have a response.
I do. Media, we have an ability, it goes to the legitimate purpose of what they're doing.
Okay, well, in regards to Exhibit D and the questioning, the objection is irrelevant to these proceedings. Your response?
Are you talking to me, Judge?
To
No?
me, Judge, the issue is, you're going to be considering what is a legitimate purpose. She's a public figure, and put aside Mr. Irving and Dr. Spees, they are media. So media has a...
Well, hold on. The objection is overruled. You may proceed.
And you identify this media news agency as the Kansas Freedom News, Richard Smith, Lawrence Accountability, Dr. Justin Spees, and Michael Irving on page 5, correct?
Yes.
You mentioned privacy. You worried that something Mr. Irving has done has revealed your home address?
Yes, he put my tag out on his live stream.
Your home and you think that's a basis why the judge should grant your motion here today? Yes?
Part of it.
Okay, but
It's not the primary basis.
no, get it. But it's still, you think your home address is private. And that's what, so one of the things you think Mr. Irving did that was incorrect, correct?
Absolutely.
Do you file for elected office?
I do.
And when you make that application, don't you have to submit your home address?
I do, unfortunately.
And that's a public record, isn't it?
It is if someone requests it.
Okay. So your residential address is not private, is it?
It's not, it is on my election paperwork.
Yeah.
But
Now,
that's not
you
on
said-
mainstream media.
You don't think he couldn't publicize what you filed as a public record, your address? You think that's wrong?
He could request it, and if he put it out there, it would be an issue, but
An issue for you,
it is a public record to get.
and that's one of the things you think he's done, which is the basis for your motion here today, correct?
He put my tag number out there.
Asking about your residential address.
He gave access to that, yes.
Now, how do you know that he gave out your residential address?
Individuals let me know that he had been filming me and they saw it.
Okay. And you, okay. And then as far as, you say that no one can photograph you or your vehicle on Elk County property? Is that your contention here today?
I think that I could be photographed in a lot of places, but that's not the sole basis, and that's not in my petition.
Object as non-responsive. Are you
I'll object as to
Hold
relevance.
on. If there's an objection, wait for me to make a ruling. The ruling is, or the objection is sustained. Please keep your answers to what has been questioned.
You need me to repeat the question.
I'm going to object to anything regarding this motion in the line of questioning is not relevant as to what is in the petition for protection.
You say that no one can photograph you or your car in public,
I
correct?
believe the judge has to rule on my objection before we go further.
All right. The objection is overruled. The part of the test that this case has on stalking is going to be course of conduct. Constitutionally protected activity is not included within the meaning of, quote, course of conduct. So if there's arguments in regards to constitutionality of things, I'm going to hear it. But let's please stay on point.
Okay. Well, my contention is you think that photographing you or your car on Elk County property is private. Isn't that correct?
It's an invasion of privacy.
All right. And you don't think anybody should be able to photograph you or your car that's parked down there in that Ford, whatever it is that you're driving, that I saw. Isn't that correct?
That's not what the motion says. So no, you're not correct.
How about photographing you in your car? Does that violate your rights as a public prosecutor, the chief Elk County law enforcement officer?
It does not, but that's not what the motion is about. You're mischaracterizing the motion.
You go on, you say in that motion on page 8, you say that you have to have thick skin because you're a public official, correct?
I do.
And that you should accept derogatory language. You say that.
I do.
And then you go on to acknowledge that you are different from clerks. The line is far narrower for them, right?
That is correct.
So in your Jill Gillette world, you ought to be able to bear up under more derogatory remarks and say a non-public official, a clerk.
That is correct, because that's the law.
You obtained Axon and security camera footage. You said that you got that through a subpoena. Is that correct?
Absolutely.
And you're testifying here under oath that prior to his delivery here in this courtroom, that you had not reviewed any of those Axon or security footage. Is that correct?
Absolutely.
And that footage that you had was on a laptop that you had in this court?
No.
When I saw you with the footage, and we were looking at the files on that, of that security footage, you're telling me that's not the footage?
It was on the thumb drive the sheriff brought me. It's not on my laptop. No, it was not on my laptop.
Okay, it was on a thumb drive. And do you have
Absolutely.
that thumb drive that was subpoenaed?
Absolutely, the sheriff brought it.
And the laptop that you were using at that, who owns that?
It was just purchased for my use at Greenwood County.
Elk County, okay, so county owns that?
Yes.
Okay.
We just bought it.
If you look at that Walker motion, you mentioned 2 core requests on page 3.
Yes, he sent some core requests.
Yes. You filed those as exhibits in the Walker case?
I'm not sure if I have or not.
And they were the core requests from Mr. Irving?
He did make core requests.
Were those 2 core requests you referred to in that motion, the Irving core requests?
Yes.
Okay. Now, you said those needed to be sealed in that motion, in that case, right?
I did ask for them to be sealed in that case.
And they were sealed.
They are now, yes.
But in this case, you went ahead and revealed those same documents, correct?
Not the responses.
The requests. You revealed the requests.
No, you're mischaracterizing the question. I'm going to object to mischaracterization.
Okay, counsel, I'm not sure where we're at here.
Well, here's the thing. We're talking about what is private and what is not. But I'll move on.
All right, questions withdrawn.
All right. You complained in the Walker motion that the request could get video footage of the live streaming to the courthouse on security cameras of Elk County in page 3, correct?
Correct.
You said those are not public videos.
They are not.
Why did you publicize that video, security video, in this proceeding here if it was not public and should have been secure?
That's why I asked for this proceeding to be sealed, and you can subpoena at any given time the subpoena of the Ducis Tecum to bring security footage to the court, but I asked the judge not to give you a copy and for it only to be used for this court hearing. That is sealing it to this court hearing, which is a PFS and is not readily accessible to the public.
You think this proceeding is still closed with all these witnesses?
As far as security purposes are, it's not being put out on the media.
Okay, let's do this. And you said it's not footage for a case in that motion, correct?
Correct,
But
absolutely.
it is footage for this case.
If someone were to subpoena, it could be
You used it as footage for your case, correct?
through proper courtroom procedure.
And you said in Walker, if it was given to the public, it would allow individuals to know exactly where the cameras are, what they view, and how they plan or plot a security breach, right?
Correct?
And you just played a video that you said would do all of those things in open court, didn't you?
During a protection from stalking.
Counsel, how is that relevant to the stalking case?
Because it goes to her credibility, Judge. She makes a statement in one court and says, oh no, this is all, but when it comes to her, personally, all rules are off and she gets to disclose any and everything. So it's an inconsistent statement. It goes directly to her credibility.
Counsel, are you saying that when there's a trial and things that may be not open to the public, they can't be used as an exhibit in the trial?
What I am saying is she made affirmative statements to the court saying you can't show these security because it's going to, everybody will terrorize us and all that. Yet when it comes to her own personal interest, all bets are off, and then she enters it as an exhibit in a public hearing. It goes to her credibility. Which one is true?
Okay, you've made your point. Let's move on.
All right. On November 6th, you said that video that you entered was a continued course of conduct.
Yes.
The continued course of conduct was Mr. Irving going to the clerk's office. That's what we saw in the video.
No, his continued course of conduct was coming towards me at the trial.
And you're not telling the court that Mr. Irving doesn't have a legitimate reason to go to the Elk County clerk's window, are you?
No,
In fact, he has a legitimate reason to be in this building, correct?
kind of, yes.
And you say what?
Kind of,
Kinda. Kinda has a legitimate reason,
yes, kind of.
okay? But he still has one.
He has an interest in the Walker trial. I don't believe that it's appropriate for him to be here to harass me. I don't believe it's appropriate for him to be here for other reasons.
I'm not asking about any of that. I'm asking about legitimate reasons. He has a legitimate reason to come to the court and go to that clerk's window and ask about documents in this case, doesn't he?
He can.
And that's a legitimate reason, isn't it?
That would be a legitimate reason.
Okay. And in fact, he has a legitimate reason to come and watch trials as a citizen,
Yes, he may.
as a journalist.
Yes, he may.
All right? And he has a legitimate interest in talking to the county prosecutor and the chief law enforcement officer about charges that may be pending against him.
If it is an actual charge of pending against him.
He has a legitimate interest to find that out, doesn't he?
In a proper form, but you can't hide an improper action in a proper one.
Yeah, okay, that's what you say, correct?
Correct.
All right. And let's look at your emails. And I've got them marked as Exhibit A.
Absolutely.
Okay,
They're up here already.
And it's A.
Yes.
All right, now, are these a repeat of what's been marked as,
Yes,
they're
they're identical.
In a way, these are in chronological orders. Hers are not. So this is chronological, and I want to go through the chronology. But there should be a duplication. This is just in chronological order.
okay, thank you.
And Judge, I move to admit these exhibits that I've,
Okay, which exhibits?
A, B, C, D, G.
I only have A, D, and G. B was already admitted, it's a video. B1 and 2 are 2 videos.
G was a Sampson, it's a, you could take judicial notice of it, but
We only have A, D, and G, and B was already admitted.
C is your complaint.
Okay, defendants A, D, and G. Now, some of these have exhibit stickers and some do not. What are the ones with the exhibit stickers?
I think the witness.
I have them.
Okay, so A, D, and G is what I have, and the G I have is not the exhibit sticker, it's a copy of that.
And then I have,
Are those the ones that are offered now?
and then I have a C that's the complaint that he handed. It's the petition.
I'd move to admit those.
Any objection to those? Those are admitted. So A, C, D, and G defendants are admitted.
All right, so if you look at A, those are comprise the communications that you say exist from Mr. Irby to you,
Absolutely.
okay? July 3rd is the first one.
Yep.
You're claiming, and then the second one is July 9th, correct?
Yes.
And you identified those 2 emails as one of 2 course of conduct events that substantiate your complaint, correct?
No, they're just examples to the judge.
Well,
They're part of the complaint, so the judge could see all of it.
I don't need to have you argue with me. You said in your complaint, you listed incidents, and then you listed 9. Isn't that correct?
They are conduct, they are contact with me.
They are the course of conduct and that you list. You list 9 course of conduct events, correct?
Absolutely.
Okay, so let's talk about the first 2 course of conduct events that you claim support your petition. The July 3rd email and the July 9th email.
Yep.
You claim that each one would cause a reasonable person to suffer substantial emotional distress. Correct?
I don't allege that in my complaint that those specifically cause it. I just say they're part of the conduct.
Okay. So to be a course of conduct, you know it has to cause a reasonable person to suffer substantial emotional distress, correct?
Correct. But I'm not going to hide something from the judge.
So let's just admit. So neither the July 3rd nor the July 9th email, you're not claiming they would cause a reasonable person to suffer substantial emotional distress, correct?
No.
You agree with me?
Oh, yeah.
And they wouldn't place a person in reasonable fear for his or her safety, correct?
No.
You agree with me?
Sure.
Okay. And you agree with those emails was not conduct that, quote, seriously alarmed, annoyed, tormented, or terrorized you, correct?
Right.
You agree?
Yeah.
And that you're not claiming that they didn't have a legitimate purpose,
Nope.
and that they were, in fact, protected activity.
He could email those emails.
All right. And so, well, let's keep going. So, July 3rd and July 9th, he hadn't done anything in your mind to constitute a violation of the stalking statute, correct?
Not yet.
Okay. Well, let's keep going. How about July 21st? You listed that as an event.
There is information in there that would alarm someone.
Well, let's talk about that. You're telling this judge this email would have caused a reasonable person to suffer substantial emotional distress. Is that what you're
Pardon me,
claiming?
counsel, I want to be sure I'm looking at the same thing. This is D, or no?
Yes, it's Exhibit A,
A, all right.
and it's July, and I've got it greened out.
It has an F at the bottom
July
of the
20.
page.
Yeah, July 21st.
Okay, thank you.
All right.
Let you know.
So, July 21st, you have an email that's captioned Cora request, isn't it?
It is captioned Cora request.
Okay, and it's from Lawrence Accountability, correct?
Yes,
That's that media news outlet that you identified, correct?
yes,
And then it's addressed to all the commissioners at their official email addresses, correct?
it is.
And then one's to the sheriff at his official address.
Yes,
And then there's another one, Doug Blacks at the Kansas House KSGov.
yes,
And then there's a one to the Senate official email,
yes,
correct? And it's one to the CO attorney at Elk County's org.
that is
And
correct.
that's your official email address, correct?
Yes,
And you're not claiming that Mr. Irby ever emailed you anything to your personal email address, are you?
nope,
Okay? And you're claiming that in this Cora request, are you telling the court that he didn't have a legitimate, that the media didn't have a legitimate interest in making a Cora request?
I'm going to object because that's mischaracterizing what's in the email. He has the right to make a Cora request.
Overruled, you can answer the question.
He can make a Cora request.
That's legitimate.
A Cora request is.
That's legitimate.
Correct.
Okay. And in it, he says, he's talking to them about certain situations. And he has a right to email and talk to these representatives, doesn't he?
He can email and talk to representatives.
And that's legitimate, isn't it?
That part is.
Okay. And where in this email are you claiming that something in this Cora request would cause a reasonable person to suffer substantial emotional distress?
It's not about substantial emotional distress.
I'm asking that question. Where, if any, would what he said would cause a reasonable person to
I'm
suffer?
going to object because you're trying to use a legal definition in the question, and that's
No,
trying to
no.
make an argument.
The objection is overruled. If there's something in here that, if it doesn't show something that believe it meets that description, then you can say so. If it does, then you can say that.
So in here, he
No,
says,
I asked that question. I want you to identify if it is something that he said.
absolutely,
Let
yes.
me finish.
Okay,
Something he said.
hold on. Now, counsel, you're both experienced. You know the rule. One person talks at a time. So wait until he asks the question before you speak. And when she speaks and answers, then don't interrupt. So we can't have both attorneys speaking at the same time. Please, let's go.
Thank you, Judge. Here's my question. It's very discreet. Identify where in Exhibit A on the July 21st email where anything that Mr. Irby said would place a reasonable person to suffer substantial emotional distress.
So in paragraph 2, he says, I and my associates are not uninformed rural folk who will go along with your lawlessness, nor will we just go away. That was assured for you by the lies Jill Gillette enunciated in Judge
I don't need
Ricky's
it
courtroom.
read. He's not asking you to read that. If that's a portion that you believe is responsive to what a threat is, or however it's phrased, then please tell us that, what the concern is.
That part coupled with the behaviors that were happening,
Not asking about behaviors. I'm asking about something, this email only. So you've read something you say that would cause a reasonable person to suffer substantial emotional distress. That part you just read, you're claiming that would do that, correct?
It's not just it, but that adds to it,
I'm
yes.
asking only about this email.
That part bothers me, yes.
I didn't ask if it bothered you.
Yep,
Not asking that. That's not the standard. You realize that. Just because he bothers you doesn't mean he's stalking you, right?
that part does.
Well, other than bothering you, can you identify then anything in that email that would cause a reasonable person to suffer substantial emotional distress? Yes or no?
That part does, yes.
Okay. Anything else? And while let me withdraw that question. The reasonable person is, who are you saying this would cause substantial emotional distress to in this email?
Me.
You. Okay. Now, let's ask the other one. Where in the email would place a person in reasonable fear of his or her safety? What did he say in this core request on July 21st?
That same section.
Okay. All right. And sending this email, you claim was conduct that seriously alarmed, annoyed, tormented, or terrorized you. Correct?
That section and the last section where he talks about the other threats.
And you're claiming that nothing he said in here serves a legitimate purpose or was protected activity. That's your claim here today.
No, part of it can be.
I'm asking what part, if he had a legitimate purpose and it was protected activity, what part's not?
Those parts that he goes into. The second paragraph beginning and the last paragraph.
The one you read.
The one I read in the last
The
paragraph.
last paragraph, in closing, you can choose to use lies and hyperbole to attempt to turn our words or actions into some sort of threat. That sentence,
Yes, the last paragraph.
I just read the first line of that last paragraph. That one causes a reasonable person to have substantial emotional distress,
Yep,
and they're in fear of their life,
yep.
and that has no legitimate purpose, nor is it protected activity in your world, right?
No legitimate purpose.
And then he says, I strongly encourage you to pursue all true threats like the one mentioned by Jill during the hearing.
Again, counsel, like I told her,
Okay.
I don't need it read into.
All right. Do you know if he's even talking to you?
I'm one of the people who the audience is of that email.
Okay. All right. And he said, all right, let's move on then. So now we've got one course of conduct that you say occurred on July 21st, and then we have the July 29th meeting,
Yes,
right? So as of July 29th, you have two events that you say meet the statutory requirements of bringing a stalking claim against Mr. Irving, correct?
beginning to yes.
Well, that was nice. Beginning to, or does it?
I felt it really met the actual, what I feel is the letter and the meaning of the statute when he caused physical contact with me.
Okay, so having said that, you've got two events that you claim meet the statutory requirements as of July 29th. Isn't that correct?
I could, yes.
And you didn't file anything as of July 29th, even though you claim you were terrorized and emotionally distressed and in physical fear of your harm, right?
Correct.
So let's go on. July 29th. You sought, in the Wonker motion, you sought all kinds of ex parte relief against Lawrence Accountability.
Let me interrupt here. Okay, it seems like we're getting into a little different area. It is almost noon.
Okay.
I'm going to recess until 2 o'clock or soon thereafter as my hearing is done and we can begin, and we'll pick up with that. We're in noon adjournment.
Judge, do you want the exhibits left up here?
If they have been marked and, if they've been marked, yes, they need to be left with the court, if they've been mentioned. Not necessarily admitted, but, most of these have been admitted, but if they've been marked and mentioned, I need to keep them at this point. So if council have those, please bring them to the bench and we'll keep them here.
Well, they would be here.
Yeah, approach your honor.
Yes, both of you can. Mr. Baker, do you have anything like that?
No, I don't have any original exhibits. You've got it.
Thank you, then we're adjourned.